Morning, everyone. All right. Welcome to February 21st, 2026, the meeting of the Elkhart City Board of Zoning Appeals. Video comments will only be taken on WebEx, and you cannot comment on Facebook. You can only watch. If you're joining by video, please mute your microphone when not speaking. When you begin to speak, speak up and identify yourself before proceeding. If you're speaking, you must have your video on so that you can appear on screen. When speaking, petitioner, public, and board members, make sure your mic is on. The purpose of this meeting is to review and consider all relief from any standard in the zoning ordinance, including variance uses, special exceptions, conditional use request, and administrative appeals. All of the cases heard today will have a positive, negative, or no decision made by the board. If no decision is made, the petition will be set for another hearing. If a decision is made that you disagree with, either as the petitioner or an interested party, you must file for an appeal of the decision of the board no later than 30 days after the decision is made in an appropriate court. If you think you may potentially want to appeal a decision of the board, you must give this board a written appearance before the hearing. If you're in person, please sign in. The sheet is provided, which will act as an appearance. You should sign the sheet if you want to speak, but also if you do not wish to speak, but you might want to appeal our decision. If you're appearing on WebEx, please put your name and address in the comment section. A written petition that is set for a hearing today satisfies the requirements for the petitioner. If you file an appeal later than 30 days after the decision of this board or give no written appearance today, you may not appeal the decision of the board. Because the rules on appeal are statutory and specific on what you can do, the board highly suggests you seek legal advice. If you are the petitioner, in addition to filing for an appeal, you must first file a motion for a rehearing within 14 days of the board's decision. All right, and then today we have our minimum quorum, and there are 3 members present, which may include temporary or appointed members. While we can conduct business with 3 members, any votes must be unanimous. Anything less than unanimous will be considered no action, and the case will be reset for next month. Our temporary appointee members will allow us to take action on all items. Okay, public comments. With respect to the public comment portion of the meeting, public comments will be taken only on the specific petition being heard before the board. Unlike city council meetings, there's a time for anyone to comment on any issue. We do not have that at the BZA, and the comments will only be taken for or against the petition before the board. Okay. That is all for that. And then our first, sorry. Go ahead, Maggie.
If I may, Maggie Marnoka, I'm the board's attorney. I believe everyone is aware of this, but I just want to say the reason for today's special meeting, is we realized that it's my understanding there was some kind of software glitch that we use when we send out notices. And we discovered that people hadn't gotten adequate notice on the items that are on this agenda. So today, when they're heard, they'll be heard as new petitions.
Okay.
Thanks.
All right, roll call.
Lightman.
Here.
Lindley.
Here.
Newbill.
Here.
Evandra Rakoff.
Okay. Can I get approval of the agenda?
So moved.
Sorry.
I do have one amendment to the agenda, 25 UV08 for 641 West Lexington. I was able to confirm the property has sold subsequent to the original hearing. And it is being used as a single-family dwelling, so we will not need to hear that petition this morning.
Okay.
So we would just need
What number was that?
UV 08, the first item on the agenda for 641 West Lexington.
Okay,
Property is being used as a single-family dwelling, so we will not need to hear that petition. It may be removed from the agenda.
thank you.
Okay. Approval?
I'll make it, motion to approve the agenda as amended with the removal of item number 1.
Second.
And then approval of proof of publication?
You have to do those.
Oh, sorry. Roll call. I'm not used to Saturday mornings.
Lindley? Yes. Newbill?
Yes,
Lightman?
Yes. Okay. And then approval of proofs of publication.
Make a motion to approve the proofs of publication provided in our packets.
second.
Okay. Roll call.
Lindley? Yes. Newbill?
Yes,
Lightman?
Yes. Okay. So first up will be 25 BZA 22. Petitioners Aaron Yoder and Christina Yoder, and the property is located at 1305 Cedar Street.
The request is to vary from section 26(4)(a)(6), which states in part, no fences other than split rail, wrought iron, or open picket fences not to exceed 4 feet in height shall be permitted in any front yard or corner side yard. To allow for a 6-foot privacy fence installed that is to remain in the corner side yard. The corner side yard height variance of 2 feet and material standards for solid privacy variance to remain for the same fence. I don't believe the petitioner will be here this morning. He had to work. So I'm just going to go ahead and read the staff analysis. Again, the petitioner is requesting a developmental variance to allow for a 6-foot privacy fence in a corner yard when 4 feet is the maximum height, and to allow solid material when non-opaque material is allowed. Zoning staff cited the property for a zoning violation for the 6-foot wood fence installed in the corner side yard prohibited by the zoning ordinance on July 1, 2025. A 4-foot chain link fence was removed and replaced by a privacy fence. Upon investigation, no permit for the fence was found. The petitioner submitted a fence permit on July 8, 2025, and was denied by staff on July 31 for not meeting the requirements for fencing in the front or corner side yard. The petitioner then submitted to the board for a developmental variance on August 8, 2025. The petitioner is seeking this variance to allow the now existing fence to remain in its current location. Staff has no recommendation on the proposed variance. The city of Elkhart is in the process of updating its zoning ordinance, including fence regulations. The requested condition is consistent with the proposed regulations found in the anticipated UDO. The updated language will allow the 6-foot privacy fence 1 foot from the property line. It is difficult for staff to determine the exact location of the property line, especially with no sidewalks along Oak Street. If the petitioner can find the property corner markers with or without the assistance of a surveyor that confirms the new fence is compliant with the forthcoming ordinance language, staff would support the petitioner's request. Recommendation. And I believed during the meeting we had amended our recommendation to approval, so I will read the amended recommendation. Staff recommends approval of the developmental variance to vary from section 26(4)(b)(2) fences permitted in residential and business districts, which requires in part that in a corner lot, no fence or wall or vegetation exceeding 4 feet in height, or a fence, wall, or vegetation that is opaque may be placed, built, or installed, 1, in the required side yard adjacent to the street, or 2, in any part or any portion of the rear yard lying closer to said street than the point of the principal building nearest the street, to allow for a 6-foot opaque fence installed in the corner side yard along the Oak Street frontage to remain based on the following findings of fact. The approval will not be injurious to the public health, safety, morals, or general welfare of the community because the fence will be built and installed in a workmanlike manner. The use and value of the area adjacent to the property will not be affected in a substantially adverse manner because the fence is a typical element found in residential districts. The fence's location should not affect the use or value of the adjacent property. Number 3, granting the variance would be consistent with the intent and purpose of the ordinance because the measure of relief is allowed when warranted because it is anticipated that this location will soon be allowed in the new UDO. Number 4, special conditions and circumstances do exist as the subject property is a corner lot. Number 5, strict application of the terms of the ordinance will not result in practical difficulties in the use of the property because the fence could be designed to meet the requirements for fencing on a corner lot in the city. Number 6, special conditions and circumstances do result from an action or inaction by the applicant, and the property does not lie within a designated flood hazard area. Conditions: if the board chooses to approve the requested developmental variance, staff recommends the following conditions be placed upon the approval. Number 1, petitioner would verify the fence is 1 foot away from the property line on the Oak Street frontage. There were 41 letters mailed, none returned.
All right, do we take questions for staff and petitioner potentially at this point? Since there's
But
no
we
one,
would we open it up to the public or
then after that, we.
or questions for myself.
Okay. At this time, I'd like to open it up to the public. Anyone that would like to speak in favor? Anyone online? Okay, anyone that'd like to speak in opposition? Anyone online? Okay, at this time, we'll close the public meeting. And we've already had the staff report, but are there any questions for staff?
Yes, I have a question for staff. The fence has already been installed prior to the hearing. It was, I'm looking at the photographs. What is your time frame for confirming with the petitioner?
We will go ahead and schedule that as weather permits.
Okay.
Okay, any further questions?
No further question.
Okay. This time, I would like to, if there's a motion to go either way.
Okay.
Mhm.
I move to approve 25-BZA 22 and adopt the petitioner's documents and presentations, together with staff's finding of facts as the board finding of facts in the present petition, and adopt all conditions listed in the report.
I will second the motion.
Roll call.
Lindley,
Yes?
Newbill,
Yes.
Lightman,
Yes. Okay, next up is 25 UV09.
The petitioner is Steve Hill. The site location is 1717 Cassopolis Street. The request is to vary from section 13.2 permitted uses in the B3 Service Business District to allow for the establishment of a new daycare center at 1717 Cassopolis Street.
Okay. Would the petitioner like to come forward?
Good morning.
Good morning.
Morning.
All right, would you tell us what you'd like to do?
Well, it's,
And
What-
sorry, state your name too.
my name's Steve Hill.
Okay,
I bought the Westview Floors building and turned it into a daycare for infants to about 8th grade kids.
okay. Staff, are there any questions?
No.
No.
Didn't have any.
No questions. Okay.
I did have one question, and it can either be for petitioner or staff. And I am new to the board, so I apologize if this has been covered before. Could someone define what an unlicensed registered ministry is? I noticed that in the staff report.
It is the way the licensure from the state, it's a state title, and that is the license for this type of daycare center. We have a number of them in town. It's just the category that she is applying for her license.
Okay, thank you.
Mhm.
That's all the questions I have. Thank you very much.
Okay. At this time, we will open up the meeting for public comments in favor. Anyone in person or online that would like to speak in favor? Okay. Anyone in opposition that would like to speak in person or online? All right, at this time, we will close the public meeting and hear the staff report.
The petitioner is requesting a use variance to allow the property at 1717 Cassopolis Street to be used as a daycare center. Section 13.2 permitted uses in the B3 Service Business District do not allow or do not permit daycare centers. The need for the use variance, again, comes from the fact that the B3 zoning district does not permit daycare centers as a permitted use. The property was formerly Westview Florist and is now vacant. On the rear and side of the building is available parking. The building will require remodeling of the area for the kitchen as well as each of the bathrooms. The petitioner is seeking local permission to operate a daycare center at 1717 Cassopolis Street. The city of Elkhart requires, in addition to state approvals, local approval in order to operate a daycare center. The city of Elkhart is in the process of updating the zoning ordinance, including new uses allowed in business districts. The requested use is consistent with the proposed regulations found in the anticipated UDO. Based on assessor's records, the building was built around 1965 and is approximately 8,293 square feet over 2 levels. There's approximately 4,149 square feet on the first floor and 3,024 square feet on the second. Staff conducted a site visit of the 1717 Cassopolis building with the petitioner on September 3, 2025. Off the south side entrance of for the building, there will be a sign check-in area or sign-in check-in area for children, plus a kitchen covered heated garage for the center van to load and offload children out of the weather. The first floor is proposed to have 3 classrooms, each with attached bathrooms, for children ages newborn through 4 years old. The second floor will have rooms for older children and an area for children coming for after-school care. The second floor will also house staff offices and a staff break room. The outside of the building will have parent and staff parking on the south of the building closest to the front door. The rear of the property will be used for outdoor activities with the existing green space made usable for children's play equipment as well as additional parking during drop-off and pickup times of the day. The petitioner is also proposing to install a gate in the parking lot on the east of the building, which will open from 4 a.m. to 9 a.m. during operation. It will be closed at other times to allow the enclosed area to be used as secure outdoor play space. Peak hours of children's drop-off will be 7 a.m. to 9 a.m. The daycare center will be serving children 6 weeks to 12 years old with the potential of between 50 and 70 children, along with 10 to 12 staff. Transportation for school will be provided. The hours of operation will be from 4 a.m. to 6 p.m. Monday through Friday. The petitioner will be working to gain state approval as an unlicensed registered ministry. The daycare will necessitate a license from the Indiana Family and Social Services Administration. The building has a spacious lot for parking and the placement of playground along with 2 driveways to Cassopolis Street for drop-off and pickup of children. The staff recommends approval of the use variance based on the following findings of fact. Number 1, the approval will not be injurious to the public health, safety, morals, or general welfare of the community because the building will be updated per all applicable building codes. Number 2, the use and value of the area adjacent to the property will not be affected in a substantially adverse manner because there will be no exterior changes to the building. Number 3, granting the variance would be consistent with the intent and purpose of this ordinance because a small measure of relief when uniquely warranted. Number 4, special conditions and circumstances do exist which are peculiar to the land involved and which are not applicable to other lands or structures in the same district because without board action, a daycare center on this parcel would not be permitted. Number 5, the strict application of the terms of this ordinance will not result in practical difficulties in the use of the property because developing permitted use could be achieved with both adjacent structures used commercially and providing for required off-street parking would be possible. Number 6, the special conditions and circumstances do not result from any action or inaction by the applicant as the zoning for the property has existed for some time. And number 7, this property does not lie within a designated flood hazard area. If the board chooses to approve the requested use variance, staff recommends that the following conditions be placed upon approval. All children shall be restricted to the building and fenced-in play area except when arriving or leaving on supervised walks or outings. Number 2, the facility and grounds shall be kept clean at all times. Number 3, the facility shall be subject to inspection upon reasonable notice by the zoning administrator during hours of operation. A copy of the daycare center license shall be submitted to the Department of Planning and Zoning upon receipt from the Indiana Family and Social Services Administration. If the daycare ceases to operate for more than 1 year or the license is revoked, the use variance becomes null and void. Number 6, any violation of the terms of this use variance as determined by the city zoning administrator shall render the use variance invalid. Number 7, the maximum number of children will be determined by the state's child care staff ratio. And number 8, the renewal for the use variance will need to be submitted is for 2 years and shall be reviewed as a staff item by the Board of Zoning Appeals by September 13, 2027. There were 14 letters mailed, none returned.
Okay. Eric, does our new UDO have stuff for daycares in it?
Yes,
Okay,
and this language will carry over, all of the conditions carry over into the new.
okay, perfect. Thank you.
Mhm.
Any other questions for staff?
Yeah, I have a question. Is the fencing for that area, has that already been done or is to be done in the future?
I believe it's already been completed.
It's been, okay.
Further questions? Okay. All right. At this time, I'd like to call for a motion.
Okay. I move to approve the approve variance 2507. Whoops, I'm sorry, wrong one.
Yeah.
Oh, 09. I'm already ahead of myself. I beg your pardon. 25 UV 09 and adopt the petitioner's document and presentation together with staff finding of fact as the board's finding of fact in the presentation, and to adopt all conditions listed in the staff report.
Second.
Okay, roll call.
Lindley,
Yes?
Newbill,
Yes.
Lightman,
Yes. All right, thank you, Mr. Hill. I forgot to ask if you signed in.
I did.
Okay, perfect. Okay, thank you.
Thank you.
Okay. UV9. Okay, up next is 25X07.
The petitioners, Elisa Garcia, the site location is 721 Maple Row. The request is per section 5.3 special exception uses, 53F home daycare center to allow for the establishment of a new daycare home at 721 Maple Row.
Okay. Would the petitioner like to step forward?
Excuse me.
Good morning.
Good morning. I'm Elisa Garcia.
Would you tell us what you'd like to do here?
I would like to have a home childcare. There's fencing, there's parking in front. I received a letter saying that not all people were notified of the change I'd like to make.
Okay. And did you sign on this? Oh, perfect. Thank you. Okay. Are there any questions for the petitioner?
I have any,
Okay.
no questions.
Yeah, no questions.
No questions. Thank you.
Thank you.
Okay. At this time, I'd like to open up the meeting to the public. Anyone that would like to speak in favor, in person or online? Okay. Anyone that would like to speak in opposition in person or online? Oh, person?
David Henke, I've signed in. I'm neither in favor nor opposed generally. As daycares go, licensed and unlicensed is required by the state for the size based on the number of children. I think that's pretty important for us to understand. If there's greater than 5 children, it must be in the licensed area, approved with certification by the state for daycare. Secondly, it shows that the state is involved in monitoring the results of children for their safety. That would be another consideration for the city of Elkhart, it would be important to note if they are 501c3 tax-paying or nonprofit organizations. Thank you.
Okay. Is there anyone else that would like to speak in person or online? Okay, at this time, we will close the public meeting and hear the staff report, which I believe will state some of those things for you too.
The petitioners were submitting an application for a home daycare at 721 Maple Row. The home is located in a neighborhood with ample sidewalks, with the ability for some of the children being cared for to walk to the location. According to Elkhart County Assessor's records, the house is 904 square feet, built in 1960. The lot is 0.15 acres. At the writing of this report, staff had visited the site. It is anticipated the petitioner will apply for a Class 1 license with the state's Family and Social Services Administration, which allows for up to 12 children. Pickup and drop off for the facility will be handled from in front of the home along Maple Row on the north of the building. In terms of space, the house is adequate. The state requires for a Class 1 license a minimum of 35 square feet per child for indoor space, for a total of up to 420 square feet if the maximum number is reached. The staff recommends approval of the request based on the following findings of fact. The special exception is so defined, located, and proposed to be operated so that the public health, safety, and welfare will be protected. Number two, the special exception will not reduce the values or other properties in its immediate vicinity because there will be no exterior changes to the existing building. And number three, the special exception shall conform to the regulations of the zoning ordinance in which it is to be located because it will not generate adverse effects on adjacent properties in the form of noise, smoke, or odor. If the board chooses to approve the requested special exception, staff recommends that the following conditions be placed upon the approval. Number one, the petitioner shall submit plans for any building renovations to the building department within 14 days of approval and obtain permits for any work to be done within 45 days of the approval. Number two, all children shall be restricted to the building and fenced-in play area when arriving or leaving or on supervised walks or outings. Number three, the facility and grounds shall be kept clean at all times. Number four, the facility shall be subject to inspection upon reasonable notice by the zoning administrator during hours of operation. Number five, there shall be no exterior display of signs or other forms of advertising on the premises. Number six, a copy of the child care home license shall be submitted to the Department of Planning and Zoning upon receipt from the Indiana Family and Social Services Administration. Number seven, if the daycare ceases to operate for more than 1 year or the license is revoked, the special exception becomes null and void. Any violations of the terms of the special exception as determined by the city zoning administrator shall render the special exception invalid. Number nine, that there shall be a maximum of 12 children. Number 10, pickup and drop off shall be from the street at the front of the property. The special exception is for 2 years and shall be reviewed as a staff item by the Board of Zoning Appeals by October 7, 2027. It did come to the Plan Commission, or from the Plan Commission, with a do-pass recommendation. And there were 46 letters mailed, one received back. Dear BZA, I am writing to express my strong support of Elisa Garcia's request for special exception to use, special exception used to operate a daycare from their home. My family and I have lived across from the Garcias for over 15 years, and during that time, we have had the privilege of watching them raise, care for their children with exceptional dedication, patience, and kindness. They will consistently demonstrate a nurturing environment, strong family values, and genuine commitment to the well-being of children. Based on our longstanding relationship as neighbors, I'm confident they would provide a safe, structured, and positive daycare setting for families in our community. The Garcias have always been respectful neighbors who contribute positively to the neighborhood atmosphere. I believe their proposed daycare would be a valued asset by offering much-needed childcare while maintaining the character and integrity of our residential area. It's clear to me that Ms. Garcia possesses the temperament, responsibility, and care necessary to successfully operate a small, high-quality daycare. I fully support their request and respectfully encourage you to approve their special exception use.
How nice.
Okay, questions for staff? I have a question. All of the conditions that were placed on this, are these part of the updated?
Yes.
Yeah, okay.
Mhm.
Nothing else varies. Okay.
The changes to the building have to be done within 45 days of our approval or of when the building permits are pulled?
That is our standard condition in the event that there are changes. We don't anticipate any for
Okay,
that property.
thank you.
Mhm.
Okay. Do you have any more questions? Okay, at this time, I'd like to call for a motion.
Okay, I move to approve 25-X-07 and adopt the petitioner's documents and presentations together with staff's finding of facts as the board's finding of facts in the present petition, and adopt all conditions listed in the staff report.
Second?
Okay, roll call.
Lindley,
Yes?
Newbill,
Yes,
Lightman,
Yes. Okay. Thank you for coming in this morning again and presenting to us.
thank you.
Okay, next up is 25 BZA 23.
The petition is Gadu Korlawala. The site location is 1034 Princeton Street. The request is to vary from section 26(4)(a)(6), which states in part, no fences other than split rail, wrought iron, or open picket fences not to exceed 4 feet in height shall be permitted in any front yard or corner side yard to allow for a 6-foot high privacy fence installed to remain in the corner side yard. A corner side yard height variance of 2 feet and material standard solid privacy variance to remain for the same fence.
Okay. Would the petitioner like to come up and speak?
Yes, my name is Gedo Koliwara. We was back here, I think, in
Can you
July.
pull the microphone down? Thank you.
Yeah, I think we was back here in July to get approval. We went home, we celebrated, and then I received a letter in the mail, so back here again.
Okay. Thank you for coming in. We appreciate it. We're sorry for that. Any questions for petitioner?
No,
Yeah, we've already read it, so thank you. Okay, at this time, I'd like to open it up to the public meeting. Anyone that is in favor that would like to speak, either in person or online? Okay, anyone that would like to speak in opposition in public or online? Okay, we'll close the public meeting at this time and hear the staff report.
The petitioner is requesting a developmental variance to allow for the 6-foot privacy fence in a corner yard when 4 foot is the maximum height, and to allow the solid material when a non-opaque material is allowed. The petitioners submitted for a fence permit on May 5th, 2025, and was approved by staff the same day. The approved permit application depicted the fence. Even with the home along Williams, a 4-foot chain link fence was removed and replaced by a 6-foot privacy fence. When the fence was installed, the placement went past the wall of the home along Williams, which does not comply with the current fence placement standards. Zoning staff cited the property for a zoning violation for the 6-foot wood fence installed on the corner side yard, prohibited by the zoning ordinance on July 2, 2025. The petitioner then submitted to the board for a developmental variance on September 5th, 2025. The original design met the development requirements from the zoning ordinance for corner side lots. The petitioner is seeking this variance to allow for the now existing fence to remain in its current location. Staff recommends approval of the proposed variance. The city is in the process of updating its zoning ordinance to including fence regulations. The requested condition is consistent with the proposed regulations found in the anticipated UDO. The updated language will allow the 6-foot privacy fence 1 foot from the property line. It is difficult for staff to determine the exact location of the property line, especially with no sidewalks along Williams. If the petitioner can find the property corner markers with or without assistance of a surveyor that confirms the new fence is compliant with the forthcoming ordinance language, staff supports the petitioner's request. Staff recommends approval of the developmental variance based on the following findings of fact. The approval will not be injurious to the public safety, public health, or morals, or general welfare of the community because the fence will be built and installed in a workmanlike manner. Number two, the use and the value of the area adjacent to the property will not be affected in a substantially adverse manner because the fence is a typical element found in residential districts. The fence location should not affect the use and value of an adjacent property. Number three, granting the variance would be consistent with the intent and purpose of this ordinance because a measure of relief is allowed when warranted, because it is anticipated that the location will be allowed in the new UDO. Number four, special conditions and circumstances do exist as the subject property is a corner lot. Number five, the strict applications of the terms of this ordinance will not result in practical difficulties in the use of the property because the fence could be designed to meet the requirements for fencing in the corner lot in the city. And number six, special conditions and circumstances do result from action or inaction by the applicant. And number seven, the property does not lie within a designated flood hazard area. There were 38 letters mailed, none received.
Any questions for staff?
I have a quick question. In looking at the photographs provided in the packet, am I correct in thinking that the new privacy fence follows the original footprint of the chain link fence, regardless of what was presented earlier in the summer?
I think it's very close.
It's very close. Okay. That's the only question I had.
No questions.
All right, at this time, I'd like to call for a motion.
I move to approve variance 25 BZA-23 and adopt the petitioner's documents and presentation together with the staff's finding of fact as the board's finding of fact in the present petition.
Second.
Roll call. Lindley,
Yes?
Newbill,
Yes.
Lightman.
Yes. All right, thank you for coming in and presenting again. Have a good day. Go continue celebrating.
Yes.
Okay, next up is 25 UV10.
The petitioner is Nicole Hogendobler. The site location is 1746 East Beardsley Avenue. The request is to vary from the uses found in section 4.2 permitted uses in the R2 one-family dwelling district to allow for the construction of one accessory dwelling unit. Also to vary from section 26(1)(b)(8)(a), which states in part accessory buildings on property occupied by one or two family residential uses shall be limited to a maximum floor area of 720 square feet for the largest structure with a maximum total of 840 square feet for all accessory buildings combined to allow for the proposed accessory dwelling unit at 748 square feet, where the maximum for any one structure is 720 square feet, a variance of 28 square feet, to also vary from the maximum total area for all structures of 840 square feet to allow for a total area of all accessory structures of 1,148 square feet, a variance of 308 square feet. To vary from section 26(1)(b)(8)(a), which states in part a maximum of two accessory buildings allowed on each lot to allow for the total of four accessory buildings, a variance of 2, including the proposed accessory dwelling unit. And to vary from section 26(11) or 26(1)(b)(11), which state no accessory structure shall be used for permanent or temporary habitation to allow for the accessory dwelling unit to be used for habitation.
Okay. Would the petitioner like to come forward? Good morning. All right.
Good morning. My name is Nicole Hogendobler. I'm the owner and occupant of 1746 East Beardsley. As was presented and approved on October 9th, I petitioned to add a mother-in-law suite to my property. He's going to pass out pictures of the current state that it's in right now so you guys can see how it's going. The home's approximately 56 feet by 13 feet 4 inches. It's 748 square feet. It's only going to be occupied by my mother and doesn't require a separate mailing address or any, it's going to be hooked to my existing utilities. Adherence to the zoning requirements at this point would be a very unusual hardship for both myself and my mother. The home's already installed due to already receiving approval. The home is also installed on a cement crawl space that was required by the inspector, costing us an extra $8,000 that we didn't know we were going to need to do. My mom's already closed on her current home and is technically a squatter in her own home while we're waiting on this to be resolved. My mom has chronic health conditions that are going to worsen over time and require her to have more assistance as she ages. She's already requires some assistance in keeping up with her housework and yard work. Her living so close to me will allow me to give her help timely and allow her to be taken care of as she ages and be healthy and happy. Rescinding the prior approval will result in extreme financial hardship to the home due to the home already being bought and installed. More importantly, the denial will place my mother farther away and unable to obtain the help she will need in a timely and safe manner. I've previously worked as a CNA in a retirement home, and I've made myself the personal promise my mom will never live in one. The standards considered for the use variance according to Indiana Code 3674-918.4 are all true in this circumstance. The first standard that the approval will not be injurious to the public health, safety, morals, and general welfare of the community is true because the addition of the property is not harming anyone. It's not blocking any sight lines for driving. Keeping the structure actually adds to the morals of the community because it's a daughter's attempt to care for her mother. The city also agreed with this at the last meeting because the detached dwelling is built per all applicable codes. The next standard, that the use and value of the area adjacent to the property will not be affected in a substantially adverse manner, is also true. The addition of this home does not harm either of my neighbor's properties. It sits on my land and sits back out of the way. The home will be maintained and kept maintained at all times, just as my primary residence is. The city also agreed that this standard is true, stating the surrounding properties will not be adversely affected because the surrounding uses are residential and residential structures. Standard number 3, that states the need for the variance arises from some condition peculiar to the property involved, is also true. Keeping the home as it sits will be an extreme relief to both of us. And again, the city agreed with this, stating the variance would bring small measure of relief. Standard 4, stating the strict application of the terms of the zoning ordinance would constitute an unnecessary hardship if applied to the property. Requesting the variance is more true now than it was at the first meeting because the home's already installed. The truth of the standard in my original proposal was that if my mother was not allowed to reside in the home, she may not receive the help and care she needs as she ages in a timely fashion, which could lead to more serious circumstances such as loss of independence or major health problems that could have been prevented. Now that the home is already installed and paid for, the hardship is even more substantial. Her home is sold and all of her finances are tied up in this house. The city is in agreement stating special circumstances and conditions do exist which are peculiar to the land involved and which are not applicable to the other lands or structures in the same district because without board action, the adding of the accessory dwelling unit of this parcel would not be permitted. The last standard, stating that the approval does not interfere substantially with the comprehensive plan, is also true. The addition of the home is an investment to an existing residential neighborhood. It does not interfere with any type of transportation, safety, or needs. It will also not interfere with any future land use due to the fact that a regular sized home would never be eligible on my property. At the first approval, conditions were placed on my variance. The first one was only one entrance is permitted on the front facade, while the second entrance can be on the side or rear of the building. This condition came under scrutiny because nowhere in the language did it say the front had to actually face the street. So we installed the home exactly as was on the proposal. And in the actual meeting last time, it was stated on the record that the way I was installing the home would have a cleaner look when it was approved. So I consider this condition met. The second was shall be a secondary and accessory to the main unit. That's true. Shall be fully functional as an independent living space. That's true. All utilities are now hooked up to the house and it can function on its own. Shall be on the same lot as a primary dwelling and not split off of the frame. That is also true. It is not connected to my house at all. It must meet accessory standard, structure standards, setbacks. That's also true. The primary structure at ADU must be occupied by the property owner of record. A deed restriction shall be recorded with the Elkhart County Recorder. Nobody's going to live in the home but my mother. Utility connections must connect with the primary dwelling. That's true and already completed. The removal of one shed from the property to allow for 3 total structures. This has not been completed because of all of the complications we've run into and due to weather, but the shed in the picture closest to the house is coming down. It has to come down anyway. It's got holes in it. I mean, it's coming down. So I respectfully ask the board to stand behind the first approval and allow us to continue with this variance. Thank you so much.
Thank you.
Thank you. How much money have you invested so far in adding this property?
How much have you invested?
Just roughly. 100,000, okay. And then do you think all costs are done at this point, or are there more costs coming?
I honestly don't know because everything isn't completely done yet. So I don't know if we're going to run into anything else.
Okay. Okay. I'm just reviewing a couple
you're
of things. Does anyone else have any questions at this time?
I see is it a chain link fence or is that your
It's a chain.
privacy? Oh, okay.
Yep, the privacy is the neighbors.
Oh, okay. Thank you.
And where is the parking for the ADU?
We're planning on having it by the home, but it hasn't been, I haven't asked for any approvals or anything on that yet. So for right now, it'll be in my parking.
Okay, so, and are you envisioning asking for a curb cut at that time for a second driveway?
Yeah, I'm going to have to propose for that. There's actually no curb there, but I'll propose for a driveway.
Okay.
And then currently I'm just looking at the pictures here.
Mhm.
The main entrance, is that the one that is facing the fence or the one that's facing into the property?
We're envisioning the one facing the fence. Because if the parking's approved, she's going to park right there. I made sure the house was a driveway length away so she could pull her car up right to those steps.
Okay, so the one facing the fence is
Yeah.
gonna be the main entrance, okay. Okay, any other questions?
I have none for the applicant.
Okay,
Thank you.
okay.
Thank you so much.
Okay, at this time, I would like to open up to the public. Anyone that is in favor that would like to speak in person or online? Okay, anyone that would like to speak in opposition, in favor, or online? Oh, I'm sorry. In opposition. Anyone that would like to speak in opposition, in person or online?
Good morning, Commission members. I appreciate this hearing as the first one had a failed notification, and I believe.
Will you state your name for us
David,
just for the record?
yeah, sorry, David Henke. I'm the city councilman for this area.
Thank you.
So several things to look at. Number one, an emotional presentation does not facilitate the 3 questions before the BZA. There are simple 3 questions that must be met for the threshold. I would also suggest, though, since that was offered as a licensed healthcare facility administrator in the state of Indiana, the state of Michigan, $100,000 has a lot of options for care. In today, being in a brand new apartment on East Jackson would afford $100,000 already expended 6.9 years, not including current income, just the $100,000 already expended. in assisted living, which I have buildings in assisted living, that would afford with care staff and food and utilities 4.7 years, that 100,000, not including current income. So I just want that to be known. If we're looking for care for a senior citizen, there are plenty of options in Elkhart County. The process, as I'm noting, and I'm just stating this, I do work with Eric and one of the attorneys. It appears that the process doesn't work for notifications because this whole docket is filled with projects already in process or already completed, and now they come before the BZA. So notification is a real problem, but it does not negate the rights of the lateral properties. They have property rights, they have ownership rights as taxpayers. So as I go through this process, the process did fail them. When there was a known notification problem, a cease and desist should have been issued. It was not. So the project continued. It was on social media that there was a problem. Neighbors who've done their homework all around us called into the city to alert them that there was no notification. A couple did receive notification after the meeting that they were invited to attend a meeting. One person had 2 notifications, but several had 0 notification of this process. So I'm looking at the 3 areas, and I want to make this brief because it's most important that the neighbors speak. Injurious for the following reasons: the breach of resident rights for the following reasons, and I'll post those: the non-conforming financial injuries to the area, and I will provide that as well. The safety on a snow route where parking is critical, no parking on the streets because it is a noted snow route. This is a non-conforming structure in an established neighborhood. That should have raised red flags right away. Northeast quadrant is where investors want to go and build, like on the end of Calumet, like on Greenleaf Boulevard. Those are desirable areas because of the stability of the investment. This particular project does the opposite of that. It is a non-conforming use. It is a structure unlike all around it. It does add 2 livable and habitable structures on a single property with no secondary curb cut, no secondary address. Let me just read through it. It is a one-of-a-kind, dissimilar structure as a distraction to lateral houses. That's a fact. It is placed near 2 property lines that encroaches on neighbors' privacy. That's a fact. Entry steps are too close to the property line, whereas the step stops, if you add what you're required to add as far as the walkway, you're too close to the property line. There's no curb cut. There's no driveway. There's no parking. So far, there's been yard parking, which is also illegal. There's no actual address to the property. That's a problem as well, because after this family, what happens? Is it then a conforming use? Can it be used as an actual rental property? In which case, it violates rental registration law. The lack of notification to neighbors, the lack of timely notification, the lack of neighbors' public input, no cease and desist was given, so a violation of the rights of the people who are in your audience today and online, and those who have now signed a petition. Value. There are those that will speak to the value. It's a perceived value as well. But if this property is unusual, you can say it adds value to that particular property. But when you're doing comps as a realtor, we do have 2 realtors here, that comp cannot be used, and it can be seen as a distraction to lateral properties because of the density, the parking, and all those things we're talking about. Adds a second livable dwelling to one site, sets a very negative precedence to all. Elkhart established neighborhoods are the ones that people want to get to. And this actually picks away at what has become normalized in our housing standard for the area. It also constitutes a rental property with one utility. It interrupts trash collection. Now you're collecting trash for two houses because there's no second address. So you're going to have to combine trash services. That's a measure. That should say something. It sets precedents for others, for non-conforming property owners. How many landlords will add a property to their site now? And this is a precedent-setting issue. And the fact is, whether someone needs health care or not is not part of the equation. It allows others a second home on a single lot. The lot has not been subdivided. It creates financial harm to properties in the area. It distracts from city, county, and state property taxes because it does add density, and that's measured into AV. AV is the basis of our taxes. It depreciates faster than a site-built structure. Just a fact. It's on a cement slab. It's non-conforming in a lot of ways. In 5 years, it would become the eyesore. It would create financial harm to any resale. And it has an undetermined future, as if this family moves out, when mom is no longer in that property, what's the use of that property and how would you know? And then we have rental registration, and then we have plenty of other laws that no one is going to pay attention to. What happens to the property? Are they obligated to remove it when mom doesn't live there anymore? Again, I think the biggest harm was the notification. The biggest harm, no cease and desist was provided. This should have been stopped before it started. So we didn't get this far. And $100,000 can go a long way in other areas. We just don't put them in our backyards. Thank you.
My name is Kevin Foy. I live at 30590 North Shore Drive, Elkhart. First thing you're probably going to say, I live in the county. I own several properties in the city of Elkhart, so I am a stakeholder. I've got a relative that lives just down the street from this house. On public website, one of our city councilmen said, we can't discriminate. Yes, we can. We've been discriminating. I've been in the business 45 years, and we've discriminated on manufactured mobile homes for 45 years because we require them to go into a certain subdivision. We hammer on the developers. You got to put them here, here, or here. It will devalue the neighborhood. I sold a mobile home last year. Just got title to it, and the owner paid $146,000 for it. $146,000 for it in 2002. We sold it for $55,000. So there is a reason that it shouldn't be allowed. I drove by the property. I couldn't get out and measure because I didn't want to trespass, but it seems like it's pretty close to both property lines, front and back. And if I remember correctly, there's like a 15-foot or 10-foot side line and 10 or 15 foot in the rear. Without actually taking a tape measure there and measuring, I can't be sure, but I think it's too close to the property lines. If this precedence continues, and I've seen several here today that they went ahead and put it in without prior approval, and I know they had approval. But again, it should have been stopped when the meeting glitch came up. we've approved everything today that was put in ahead of time. So that's a dangerous precedence. I guess if it goes in, I'm gonna buy a house next to each one of you or Eric or anybody in the city council and put one and take care of my family. My in-laws, we spent over $300,000 to keep them in their homes and take care of them out of pocket. So we didn't have to put them in a nursing home. I'm sorry that, they spent the money, but it's going to devalue the properties. There's no ifs, ands, or buts. I've been in this business long enough, 45 years, that it will devalue the neighboring properties. When a mobile home goes in, several of these mobile home parks, after so many years, they don't want those mobile homes anymore. And I know we're screaming for housing in this area, but it's our fault for not putting, we've been screaming for houses 30 years ago. But we've done nothing to ramp up the builders and that. We lost a lot of builders during COVID. So I'm hoping you take all this into consideration and deny it.
I have a question for city really quick. The property line, do we know if this current structure is placed appropriately for property lines? Sorry to put you on the spot like that, but I can't find it in my, I don't know what the UDO.
The setback for accessory structures is 5 from the rear and 3 from the side.
Okay. 5 from the front? Oh, so
Rear.
rear, okay. Okay. Looking for. Sorry, just give me a second so I can look at a few things really quick. Do you have something that I say, Mr.?
Can that be better clarified? Because there are setbacks for non-inhabitables, sheds and so on. This is a setback for an inhabitable is the first question. The second question is, if the main entrance is out the back, the steps may be within that district, but then to step the next foot, you're outside that setback and there's no sidewalk there. It's just grass. You're obligated to have a walkway. So that would violate the setback on the side.
Okay. Thank you, okay. So it is 16. Okay. So do you have this? So it's 16 feet from the front and the back, or sorry, the side and at least on our property line map, it is here. Oh, I'm sorry. Nicole, do you know the measurement right now of where it sits on the property?
What I know, the contractor did exactly what's on the paper that I gave you.
Okay.
Sorry, it should be, I think it's 15 feet from her property for a driveway.
And then am I allowed to have her come up here and point out on a map?
Yeah, and I'm wondering why the city didn't have someone go out and do an official measure knowing that this was a problem, right?
Do you have a driveway currently?
Yes.
Can you just show me? I see it marked on here, but I just want to make sure the driveway is currently here. And then is there cement here? I just don't see a picture.
Yeah, there's cement all.
Okay.
Yeah. And then my neighbor's driveway is.
There's enough room for 2 cars.
I currently park in my side yard right there that's been knocked over since, but there's room for like 4 cars there.
Okay.
Yeah.
Okay. Sorry. Is there anyone else that would like to speak in opposition?
Hi, I'm Christine, and I live on Beardsley Avenue, catty corner to the property. Unfortunately, I'm on the side that doesn't hide the structure by the main house. I do have some pictures that I can show you in relation to what we were just talking about.
Okay. We have a lot of pictures. I just wanted to.
Yeah, I just don't know the angle, if it's showing really the distance.
Show us, you can.
Yes.
She has to take them to her first.
Oh,
And we'll take a look at them.
I just want to see if they're similar to any of ours.
Very.
Okay, so it's very similar to this one.
Yeah, which
Yes.
is not,
Okay,
definitely not.
okay.
Also, this is the neighbor. There's no privacy,
Mhm.
so that.
I would just like to point out that the discussion up there, not on the record.
Oh, okay.
Okay.
Okay. So, I'm sorry, what was your name again?
Christine,
Christine. So Christine was showing us a picture that is similar to our packet that was provided to us at the beginning of the meeting, on page 3. It is a view of the structure and the main entrance. So just to be clear, that's what we're looking at and talking about.
and I actually had already written a letter, but listening to the petitioner today, I felt that maybe there was more that needed to be said. After reading some of the information that she shared on Facebook, they knew in October that they were putting a mobile home in. It was presented as if they were going to build. I watched the October 9th meeting. It was presented as if they were going to build a cute little house. And the board at that time even responded back, and they assured them that they were building a cute little house. It was being constructed. That is definitely not what happened. And the plan that was presented, you can see, is a mobile home. And that was what was presented. And it has 2 bedrooms. So I'm not sure, I've never had a mother-in-law suite that's got 2 bedrooms. So I do question that. One other thing that I would say is that there's, to the previous person's point, this is basically going to be a rental property after, mom passes, right? Which is why there's probably 2 bedrooms in it, because it makes it more lucrative to rent a 2-bedroom apartment or a 2-bedroom home. Then the other thing that I would like to say, which I think my letter will be read, so I don't want to repeat the whole property value and all that kind of stuff part of it. I do feel like the board was intentionally misled in October, and the petitioner has tried to maybe play on some sympathies with the amount of money that they have spent and taking care of mom. But I think that the intent originally was to deceive not only the board, but they deceived the neighbors. They talked to the few neighbors that they did speak to, again, talked about building a cute, tiny little house. And that is not what got put there. And that is a horrible eyesore. I just purchased my house in 2025. And yep, just as the previous guy said, you know what? That's a great neighborhood. I was so happy to find a house that I'm going to be able to refurbish. I've, already put $30K into the house. And now I have to question, well, is it worth actually refurbishing this house anymore? Because I look across the street in my front yard and I see this horrible monstrosity, and it makes me question, well, this was going to be where I was hopefully going to live out my life. But now I really question it, especially with how this whole thing has progressed and how they have not ceased, even though they knew they should have stopped. They've put in the sewer this week. They've been rushing to try to get it done so that you felt that you had no recourse but to allow them to keep it. So that's all I have to say. Thank you.
Thank you. Maggie, may I ask you a question really quick? Do we know if the city has gone out to measure?
That
Oh,
would
that's an
be a
Eric
question for Eric.
Okay. Okay. Would it be?
Okay.
Okay. Would it be reasonable at this time to, and I'm really speaking out of term here, so I don't really know the appropriate action. If we don't know where this property actually sits right now, can we pause and not make a motion today because we don't have all of the facts? Or what does the council suggest?
One moment.
Okay. Okay.
Madam President, since it is a public hearing, could the rest of the public be allowed to speak before?
Oh, yes, I'm not closing the meeting by any means right now. I just wondered, just because I know that that is a huge question for everybody, the property line and is it within code? So I just want to make sure that I have the appropriate facts before.
Yeah, it stands to reason this process should have been investigated before it got this far. It should have been investigated before it even started the original meeting with the BZA. And here we are, second meeting, and without factual information with which to guide you.
Yeah.
So I apologize, you don't have the correct information.
But maybe the city does have the information.
It's my understanding that once it's approved by planning and zoning, then it goes to the building and
another
permit section.
Okay,
Yeah,
I just
a
wanted
different
to-
department of the city.
Okay, I just wanted to make that clear for everyone too. So we are not the final stop in this. Building inspection or building code has to come out and inspect the building and make sure of all those appropriate things.
So two things.
Please.
Sorry, Mike Huber, Director of Development Services for the City of Elkhart. Two things. One, prior to once the zoning clearance, the petitioner would have come in, gotten all the clearances and building permits. The building department, prior to the pad and the foundation being poured, would have made sure that it's in compliance with everything. So it's my understanding the building department did their jobs correctly to ensure the pad should be where it's located
Okay,
appropriately.
that's what I was looking for clarification on.
Thank you.
Okay, thank you. Okay, so anyone that would like to continue to speak in opposition, please come forward. Yeah. Just make sure you sign in and state your name, please. Okay.
Thank you.
Hi, our names are Adrian and Joetta Byers, and we own the property at 1779 East Beardsley Avenue.
Speak into the microphone so
Sorry.
it has to record everything.
Sorry. Our names are Adrian and Joetta Byers, and we own the property at 1779 East Beardsley Avenue, within the immediate vicinity of the subject property. We have owned this property since February 1994. We are here to formally oppose the requested variance to allow placement of a mobile home on a parcel that is already improved with a single-family dwelling. This request fails to satisfy the statutory criteria required for the granting of a variance, particularly the requirement that the approval will not be injurious to the public health, safety, morals, and general welfare, and will not alter the essential character of our neighborhood. Number one, inconsistent with established zoning intent. The subject parcel is zoned for single-family residential use. The zoning classification clearly contemplates one principal dwelling per lot. Introducing an additional dwelling unit in the form of a mobile home constitutes an effective increase in residential density and intensity use that is inconsistent with the underlying zoning scheme. Granting this variance would undermine the purpose and intent of the zoning ordinance and functionally reclassify the lot without undergoing proper rezoning process. Number two, injury to the neighborhood because of the essential character. The surrounding area is developed exclusively with site-built single-family residences on individual lots. The placement of a mobile home as a second dwelling would substantially alter the established residential character, scale, and uniformity of development patterns. The zoning ordinance is intended to preserve compatibility of land uses and structural types. This proposal introduces a housing type and lot configuration that is incompatible with the prevailing development character. Number three, adverse impact on property values. The injury to neighborhood standard includes protection against unreasonable injurious effects on neighboring property values. Residential property values are strongly influenced by neighborhood consistency, density, and conformity with zoning standards. Allowing multiple dwellings on a single parcel, particularly through variances rather than rezoning, creates uncertainty in land expectations. That uncertainty alone can diminish market confidence and negatively impact resale values of adjacent properties. Homeowners in this neighborhood purchase their homes with a reasonable expectation that zoning regulations limiting parcels to single-family use would be enforced. Number four, precedent and cumulative impact. Approval of this variance would establish a precedent for similar requests. The cumulative effect of granting such variances would gradually erode the integrity of the zoning district, resulting in the incremental density increases and incompatibility of housing types. Variance relief is intended to be granted sparingly, only in cases of demonstrated hardship unique to the property. There has been no showing that strict application of the ordinance creates a practical difficulty that cannot otherwise be remedied. Number five, failure to meet the variance standards. To approve a variance, the board must find that the hardship is unique to the property and not self-imposed. The variance is the minimum necessary to afford relief. The approval will not alter the essential character of the locality. The approval will not be injurious to the neighboring properties. This request does not meet those standards. For these reasons, we respectfully request that the board deny the variance application and uphold the integrity and zoning ordinance to protect the established character, stability, and property values within our neighborhood. Thank you for your consideration. We also went around for a petition.
Sorry, say that again.
We also went around our neighborhood and had people sign a petition. I don't know if you want that or.
I
It was
believe,
pretty much 100% of people in opposition. Some people didn't want to sign, but they were still in opposition.
okay. Actually, would we give it to Rain or Eric or Rain? Okay, please. Thank you.
There's also many, many, many signatures from online that I don't know if that's allowed or not, but we have those as well.
All right. Good morning. My name is Adrian Byers. I'm 1779 East Beardsley. I want to start off by saying, it's unfortunate that we're here. It's unfortunate for the family that made the investment. But, we have to basically follow the rules. I reside at 1779 East Beardsley, which is which is within the required notification distance of 1746 East Beardsley Avenue. As we know, we were not properly notified for this hearing and variance, and this is why we appear here today, because the board has properly reopened this matter, and I respectfully request a full and fair reconsideration. Our neighborhood's position is clear. We oppose this variance and ask that it be revoked. If the board declines to revoke it, then we ask that the record reflect our formal objection to an ADU. Any particular manufactured or mobile home being permitted by variance in an R2 neighborhood now or in the future be permitted as now or now in the future be prohibited. I have several key points. Point number one is due process was violated, and which basically the board has reopened this specifically because the notification process failed. Proper notification is due to a process requirement under Indiana law. It is not optional. We respectfully ask that the board treats today's hearing as a fresh proceeding, as we are. Weigh all evidence anew and not defer from the prior, not defer to the prior vote. The neighbors who stood to be most affected by this decision never had their day before the board. Today is that day, and we ask for a decision that reflects a complete and lawful record. Point two, no property-specific hardship exists. The record does not reflect a property-specific hardship as required under Indiana Code 3674918.4. There is nothing unique about the physical characteristics of this lot in shape, size, topography, or legal history. That makes strict application of R2 zoning unusually burdensome compared to neighboring properties. The hardship only exists because of who the current owner is and what her personal situation is. Under Indiana law, that is not sufficient to support the use of variance. We ask the board to make explicit written findings on points. If those findings cannot be made in variance, if those points cannot be made, the variance must be denied and the structure removed. Point three. HUD code manufactured homes and injurious to the neighborhood. The structure that has been placed on 1746 East Beardsley Avenue is a HUD manufactured home. This is not a detail. This is not a detail. This is essential to our objection. Our neighborhood consists of site-built homes. The residents on this block made their investments decisions based on an R2 zoning designation and expectations that neighboring structures would be site-built and consistent with the neighborhood's character. A manufactured home, even on a permitted foundation, has a distinct appearance and construction standard that is injurious to the character and to the property values. We further note that the original variance petition did not disclose that the proposed ADU would be a manufactured home. Had the neighbors known this, opposition at the original hearing would likely have been far greater. We ask the board to consider this injury as an independent basis for denial. Next point. Unit built during procedurally defective approval. A permanent manufactured home now sits on a foundation at this property. The structure was placed while the original variance was legally incomplete. This very hearing exists because that approval was procedurally defective. Construction that proceeds under a defective approval is done at the applicant's own risk. We ask the board not to allow some costs that construction to substitute the legal findings that are required. If the law and the facts do not support the variance, the appropriate remedy is denial and removal, not approval because of its inconvenience. My next point, R2 district must be protected. Every homeowner on the street purchased a property in an R2 district with the legal assurance that it would remain a single family in character. A use variance is not the appropriate vehicle to introduce an ADU, especially a manufactured home, into this neighborhood. The city has acknowledged that the Unified Development Ordinance is being drafted that would address ADUs through a proper legislative process with community input and design standards. That is the right path. Granting the variance today bypasses that process entirely and creates precedent that this board will be unable to walk back. We ask the board to protect the integrity of R2 designation and wait for the UDO process to properly address ADUs with appropriate safeguards. My next point is final. 5 simultaneous variances each. Excuse me. Before the board, so we've actually have 5 different variants that were approved at once, meaning that the ADU permitted use varying from the largest accessory structure. The actual size was called out at 720 square feet. They requested 748 square feet. That's an additional 28 square feet. Total overall structure, 840 feet is what is stated. The request was 1,148 feet, so that's 308 feet, 37% more than it should have been. And then the number of accessory buildings, code says 2 max. We have 4, I think it's down to 3, which is double the unit. And habitation of accessory structures is basically it goes against the R2 zoning as it's permitted or prohibited, but it's been permitted for full use and variance. So my question is, has the required shed been removed and verified by the city? Has the owner occupancy deed restriction been recorded with the Elkhart County record? Has the city staff confirmed utilities are shared and not independently metered? Has the structure been inspected to confirm compliance with accessory structure setbacks? Was the HUD code manufactured home specifically disclosed in the petition? And does the variance approval cover the specific structure type? And how will the owner occupancy restriction be enforced for future sales? Before the board takes any action today, we ask the staff to confirm on record that each of the conditions from the original approval has been independently verified and documented. We also ask that the board clarify whether the approval variance specifically authorized a HUD code manufactured home or whether the structure installed differs in type from what was presented to the board. If the installed structure type was not specifically approved, variance does not cover it. And the petitioner must return with a corrected application. Before I go into closing, I'd like to make the clarify in terms of the legal analysis of the variance. And basically, it's unnecessary hardship in terms of having the structure put in place. So we've got a lot of issues that have been overlooked. Of course, Dave has touched on some of them, but the fact that Beardsley is a designated high traffic snow route, and East Beardsley is designed designated snow emergency route. The driveway at 1746 is a single car driveway. Adding a second occupied household to this property creates parking and demands that this driveway and this street cannot safely accommodate. We ask the board to require a traffic and parking impact review before any approvals proceed. 2, no alley access between Beardsley and Grant. There is no alley access between Beardsley and Grant Street. Every vehicle associated with the ADU household must use the same single width Beardsley driveway at the primary residence. This is not a theoretical concern, it's a physical constraint of the specific site that makes the two household use functionally problematic and potentially unsafe. 3, the ADU is directly visible from Grant Street backyards. This ADU is directly visible from Grant Street backyard street residents. There is no alley, no buffer, and the original approved imposed screen and the original approval imposed no screening conditions. Grant Street homeowners did not consent to having a permanently occupied second dwelling unit as a backdrop of their private outdoor space. We asked the board to confirm whether Grant Street residents were included in a notification list, and if not, to recognize that as a further defect in the original process. Touching on the element of hardship to this. Requirements, the law, what the law requires. For the element to be satisfied, there must be something about the physical or legal nature of the specific partial that cause the ordinance to impose a burden greater than the imposed or similarly situated property. Classic examples recognized by Indiana courts include an oddly shaped or unusually narrow lot that cannot physically accommodate or conform structures, significant topographical challenges that may limit unusable areas, or a partial legally subdivided in a way that it is left undersized through no fault of the current owner, and unique access limitations for a specific partial. How does this case fail us? The petitioner stated hardship is that she wants to house her aging mother, and the R2 ordinance does not permit a second dwelling unit. The ordinance applies identically to every R2 lot in Elkhart. Nothing in the record documents any physical or legal characteristics on this lot that makes the ADU prohibited more burdensome here than any else in the district. Notably, the infrastructure facts newly identified single width driveways, no alley, no emergency routes, frontage, actually describes constraints that make this a lot less suitable for a second dwelling unit than the average R2 lot. These are not hardship factors for the petitioner. They are harm factors for the neighborhood. The unique hardship. Why this fails? The R2 ordinance prohibits ADUs on every single lot or on every single family lot in the district equally. Not in the record distinguish 1746 East Beardsley from its neighbors with respect to its prohibited. If the petitioner's next door neighbor wants the house her own aging parent and filed the identical application with the identical personal argument, she would have an equally valid claim under this same logic. Every R2 property owner in Elkhart could make the same argument. That precisely what's the uniqueness of this requirement. So the hardship basically is if the property is sold, the decision was made based on a personal hardship, which is not where variance should be used. So the point is if the property is sold to a new owner, that hardship doesn't carry over. So therefore that property can be utilized for who knows, rental, Airbnb, you name it. So I'm just gonna go ahead and, excuse me, I'm gonna jump over into my closing here because there are a lot of factors that have not been taken into consideration. But in closing, our neighborhood's position is clear. We ask the board to revoke the variance. The legal standard for the use of the variance has not been met. The structure installed is a HUD code manufactured home that is injurious to the established characters of the site-built R2 neighborhood and to the property values. It was placed on a foundation during a procedurally defective approval process, and 5 separate zoning deviations have been approved without an independent finding each requires. If the board declines to revoke, we ask that the record clearly reflects our objection. This approval be treated as a non-precedental, and that the city UDO process specifically addresses whether manufactured homes, ADUs, are ever appropriate in established site-built neighborhoods in Elkhart. We thank the board for your time and opportunity to be heard.
Did you get our pictures? Give them her pictures.
So I'd like to make my, I know that this is a city movement. I know it's a state movement. I know it's a national movement for ADUs for various reasons. And if they're done right, then we wouldn't be here today. The problem is that East Beardsley is a unique part of the city. It's one of the only areas to where everything kind of converges as you move further to the east, meaning that the properties become more tight. And that would be an example of Oslo and Beardsley and Greenleaf. And also it's unique that with the border between Grant and Beardsley, there is no alley separating those streets that you would typically see throughout the city. So just the uniqueness of the area makes this not appropriate to be there.
Thank you.
Did you want the answers to your questions that you were proposing on?
Well, absolutely, yes.
So I just wanted to make sure that you had some answers to those. So in the conditions that
Yes.
the petition has itself, a lot of those were answered because they are conditions on it. So Eric will read them into record here in a few minutes during his staff report. So just listen closely for that. But a lot of your questions will be answered with that.
All right.
And then I just want to clarify also, we only are hearing 3 variances, which is the square footage,
Mhm.
and then the maximum allowed accessory buildings, and then the habitation. So there were only 3 variances.
Okay.
So I just wanted to make sure that you said 5, but we only are
I
hearing.
was just touching on 5 points, but.
Oh, okay, sorry, maybe I misunderstood that. So I just wanted to make sure that you are heard and that was clarified.
Yeah.
Was the board aware that this was going to be a manufactured house?
It just said a home for us.
Yeah, from our.
And Eric will read out to you, and it'll be on record of what the petition actually says for us.
And I think the majority of those that had the opportunity to watch the hearing, the narrative was billed. And even though it was off-site built, the clarification of whether it was going to be a mobile home brought in should have been mentioned during that time. But during the hearing, nothing was mentioned about mobile home.
Okay.
So.
And then the city of Elkhart is also, and Eric will read this into record also, they're updating their UDO, which is what we base our decision off of. And it will have special exceptions and conditions with that new UDO also for
So
R2.
as you see in the pictures, you can see that there will be a parking constraint. I don't know if you had a chance to review the pictures.
We're looking at them right now. I looked at them.
Yes.
Rick's looking at them.
This is something that we commonly see down Bristol down Beardsley. I mean, we've been there for 34 years and that violates the city ordinance as well. But I believe there should be room for 3 cars with a parking space being 9 feet wide by 18 feet long. As far as a curb cut being put in place, that has yet to be decided upon. Good. Now, as far as the signatures, that was about 6 hours of time. I'm sure if I would have put a little bit more time, there would have been plenty more. You have 36 signatures within 6 hours. There has been additional signatures on social media. I don't know if that is relevant to this, but here again, Greenleaf is a high tax area that holds a lot of value in the city, and didn't make it to that street, but I guaranteed if I did, you'd have more signatures. So if the unit was done cohesively, we have a HUD house on Beardsley, a Habitat for Humanity home that blends in. You drive by it, don't even notice it. In this case, this is not blend in. Thank you for your time.
Thank you.
So, yep, come forward.
My name is Chris Johnson, and I live in the area. We actually live in a home that my parents built in 1956. I'm actually stunned by the fact that this began on October 9th, and we just stumbled into this last week, finding out what's going on. I cannot imagine why the city, I don't know if it's on your responsibility or someone else's, to take an area that is affected by this and notify them in the fall that this was coming, this was going on, and it could have been halted at that point. Now, I know that's been discussed by Congressman Henke and this other gentleman, but that's important. And we've been out of town and we come back and we find this, and it's very disturbing. Most of the things that I was going to say here have already been discussed, and I won't repeat, but I do want to make one point. When we moved into this house a few years ago, just because we hated to let it get out of the family, it has been in the family for 67 years. We did this because we liked the neighborhood. And since we moved in, we've been trying very hard to make sure that the cars aren't parked on the grass, that a semi-truck didn't have the cab in the driveway next door. And we've been reporting these things to code, who has been very responsive. In fact, the gentleman gave me his cell phone so I could call him if I needed something. But my point is, their reaction hasn't been, oh, this is ridiculous. It's been, hey, we're here to help you, because we'd apologize and say, hey, we know we've called about this, but it's reoccurring. We're here to help you because we're here to protect the neighborhood. Now, that is what I've heard. And if that's the case, this is not protection of the neighborhood. And the other thing that bothers me the most is, would you guys like to have a trailer in the lot next door? I wouldn't. And the guy next to me, who has an incredibly deep lot, I mean, it's far larger than the area we're in, he could probably get 3 of these houses in there. And I think if you approve this, what you're doing is you're going to be opening yourself up to just more compliance with this. And this isn't what these neighborhoods are for. If these people have spent $100,000 so far, they could have put a nice addition on their house. We did that for a family member. You don't have to have a trailer in your side yard. So just some thoughts for consideration. I'm stunned that we're dealing with this within the city of Elkhart.
You can come up and speak. State your name and make sure you're signed in.
My name is Bob Barnes. I live in Elkhart, and I've been doing some digging on this, and I've driven by this property, and I have to agree with this lady here. I apologize for being late. I was at another meeting discussing House Bill 1001. But the problem you have here is that I talked to Doug Miller, and I talked to Aaron Mishler last night through text and Kristen Small through text. And they said that Aaron Mishler told me that the city of Elkhart through their ADU ordinance through state law, cannot discriminate against manufactured homes. So I'm asking a question here. So is that a manufactured home or is it a mobile home? Do you need me to explain the difference between a manufactured home and a mobile home to you? Because a manufactured home is the house comes off the trailer frame and it sets on a foundation. I'm believing that mobile home, they pulled the axles out of it and set it on some kind of foundation. I haven't seen it on there or what on that, but that home is that trailer is out of place in that neighborhood. And if the banks look at manufactured home versus mobile homes, and you pay extra fees, and you got to get special financing through other means of financial institutions to finance these projects, there's something wrong with this and allowing this in the city. I'm not against adding on to your house or taking care of family members. But the problem we're going to have an issue if we don't cut this crap now, because you're going to have all these investments. I live over here and my backyard butts up to Joyce Court. Those are all rental properties, and most of them are owned by some investment company. So what's going to happen when these people move and they're going to see two houses on there? They're not helping the rent. They're not helping anything. And I'm asking, just because we don't need our property values dropping in our neighborhoods for projects like this. This is not bringing good neighbors. If you drive over there and look on the, I don't know what the road on the behind that place, everybody's house looks like a stinking golf course out there. Everybody takes pride in what they're doing. It don't even fit the architecture. There's no screening. There's a privacy fence, and it don't look like to me it was set any closer to the foundation or the border than a shed would have been treated. And we got to do better than this, and we need to do better at educating our legislators, because if that's a mobile home and not a manufactured home, they just broke they broke state law. So, thank you.
Good morning, board. My name's Michelle Korich. I live in the city of Elkhart. I have served on the Plan Commission, and I have served on this board previously. I don't envy you a minute, because I'm looking at your sheet here and I think it's obvious. This is absurd. This literally is absurd. I have several questions, and I don't want to rehash what all my neighbors said because they were all eloquent and truthful. My first question is, when exactly, what date was the petitioner notified that her original petition was heard without public comment the public not being notified? And the reason I ask is threefold. This trailer, which one of my other questions is it on a slab? Is it on piers? Is it cement? Because I live in the neighborhood like my other neighbors, and I didn't see that kind of construction, and I drive by this home twice a day, every day. The reason I ask about the date is because this trailer arrived on January the 21st. It sat in the yard for a day, and then they positioned by tearing up the yard, the sidewalk, and the curb, and the tree lawn. So property owned by we, the citizens, was damaged when this trailer was installed on January the 21st and 22nd. Then on February 19th and February 20th, which were Thursday and Friday of this past week, that is when all the construction people came. The city came and they did their inspections, and Moyer Electric came and parked their vehicles in the front of this property. That was on Friday, Thursday, and Friday of this past week. This, and I know you've gotten a bunch of pictures, so I'm sure mine aren't very different than anyone else's. But with the coming spring and snow melt and rain, what do you think of a mess that's going to make? It's a giant pile of dirt. And yesterday, when I took these pictures at 2 o'clock in the afternoon, the guy was out there digging the trenches yesterday afternoon. Now, you can't tell me that the petitioner didn't know that this meeting was happening today, and this was just magical that it happened yesterday? That makes us all look stupid. Apparently, that's what she thinks of her new neighbors, because she's only been in that house for maybe 2 years at this point.
That was the thing.
So anyway, well, nobody else was interrupted. I think the neighbors have said that this is the perception that has been left to us, the people who have lived in the neighborhood 25 years. It's a trailer parked on the grass. Illegal by zoning code. My questions, I would like to know the date. I absolutely would like to know the date of when the petitioner was informed that this didn't meet public comment and notification. The reason I come today is because in 25 years of living in this city and serving on boards and being active in our community, this is ridiculous. I brought you pictures because part of my concern is the deterioration of our community, all of our community, not just in our neighborhood where we live, although it does directly affect me, because trailers, according to national statistics, drop property values 5 to 7%. And on average, that's $12,000 to $20,000 of loss in value. One of the other things that I want to point out while I'm here is the neighbor next door, and I believe the address is 1732. That's the neighbor with the fence. What you probably haven't seen is the direction from her front porch. If she looks out her front porch in her nice fenced-in yard, she's looking at this trailer that's above, the windows are above the level of the fence. So no matter who is in this home, whether it's the mom, relatives, an Airbnb, future renters, whoever it is, they literally have no choice but to look out into her property. She has zero privacy now. The windows are above the level of the fence. That's why I question whether or not there's a cement pad, pure blocks, what it is, because it's higher. I brought you pictures because another issue that this will create eventually, because I can prove it by visual aid. Every trailer in this community ends up deteriorating faster than the homes surrounding it. These are pictures that I took at Woodlawn, near Woodlawn Nature Park. It's the exact same unit, basically. These are pictures that I took at Poplar Trailer Park on Cassopolis Street. Deterioration. Here's another unit that's exactly like the unit that just got put in, the trailer. Same skirting falling off. This one is the most distressing to me because I'm sick of hearing about AUD. And if I sat on this board, this would have never happened either. Remember the Ramada up on Cassopolis Street? This was supposed to be temporary parking for RVs, for people to come in, visit our community, and leave. The city will allow it to happen, but the city will not enforce the codes to keep it from looking like junk. This is the brand new $8 million project next to the toll road, and looking at it, right underneath it, right above it, here's the trashy city of Elkhart. This is not temporary. They added fencing. Other people have added plumbing hookups underneath their units. Does that look temporary to you? Because you'd almost have to be a fool to believe what you're seeing. This is a neighborhood. You have a choice, and it is your choice. You can either decide, and I'll give you these photographs, because this is what trailers deteriorate to. They don't just sit there and look beautiful all the time. But you have a choice. You can choose to help the deterioration go along because you see it. You see it. You drive down whatever neighborhood you live in. Would you want to live next to any of this mess? No. This is the fear. This is the fear, this is the perception, and this is the reality of the city of Elkhart. You can build it all you want. Nobody maintains it. Nobody cares. Code enforcement doesn't come out and go, that? Really? Plumbing and plywood installed to go to the septic system. It's unreasonable. The other thing that I want to stress to you, any other structure in the city of Elkhart has to hook up to water sewer supply. This is hooking up to the house. This is a completely separate structure. So how is it that the plumbing is getting out of that structure? Is the plumbing like right underneath where the skirt is, like on a trailer? And then it's going into the sewer line? I don't think that is appropriate either. How's the water getting in? More lines? So if something freezes, where does that water or sewer go? There's no proper curb cut. They've driven over a sidewalk. They've driven over tree lawn. They can't park another car in their driveway that could access that. So until whenever, she's going to park in the dirt. There's no other property that's allowed to do that. It goes against an EPA. It's zoning code. We, as a neighborhood, everybody on this list, look, It's almost the whole page. Nobody came up here really to talk about any of the other issues that were on here. Does this tell you the neighborhood cares? We care about our investment. We care about what we've put in. And the neighbors are right. There are people who maintain their yards to the umpteenth. My husband happens to be one of them. We invested $10,000 in just landscaping on our property on the outside so that our neighbors had something pretty to look at too. This is ridiculous. This is absolutely ridiculous, and you should do everything in your power to not allow this to happen. Because you, honestly, would you want to live next to this? Would you want to be the lady at 1732 and have somebody sitting in the living room on their couch being able to watch you do anything in your yard? Garden, sunbathe? Do you want that? Would you want that? Do you want that next to your house that you made an investment in? $100,000 could have built a really nice investment. And there's enough property there that they could have built a very nice addition onto that house. And I'm sorry that this is what this is. But I think you've gotten an idea, and I think you know, if you look at other trailers in this community, I think you know what it will look like in 5 or 10 years. It's just the nature of the trailer, because that's what it is. Thank you.
Maggie Marnoka, board's attorney. I would advise you to keep the comments that are opposed to the petition only here with regard to the 3 variances they're requesting. Anything else about any other areas and all the other superfluous stuff is just simply that, superfluous. And I think we all agree that we're here in this extra special session on a Saturday. As the acting president, you can confine those comments.
Okay, so just to be clear for everyone, that is the variance for the square footage use. It is the variance for a maximum of accessory dwelling. And then the variance for a habitated or a habitation versus a non-habitation dwelling.
Yes.
Okay.
Thank you.
Mhm.
Thanks for working for the
Good morning. Where's the pen?
Good morning.
Good morning. Appreciate your time, and also appreciate your efforts on the board. But I have a question before I'm obviously in opposition, generally speaking. A question I have is, this is a quasi-legislative board, correct?
Correct.
So your decisions set legal precedent? Okay. That's the nature of my opposition to this. Looking back, this came to my attention yesterday from some people that do live in the area. So I went back and I looked at your October 9th board meeting. And from perceptions of reality to me, in October, there was very little questions asked about this project. It was just like, hey, you're happy that you're taking care of mom. I've been there and done that. I don't diminish that. That's a challenge. But big picture, when we look at a variance, you have 5 criteria that you're supposed to meet, correct? And it appears on all of these, including the ones today, they're subjective in nature. The reasons given by your staff, they're not objective. So in this specific variance request, I think you're going to get unintended results for the community as we move forward. Everybody's going to want to do this. We cited the Zimmerman-Volk study, which is a market study. It's not a judicial or legislative precedent. Follows new development, maybe revitalized or rehab properties, what it was intended for, and population migration. And then we subtly put in that we're looking to modify the comprehensive zoning plan for AU to be dwelling. R2 strictly states they're not to be for dwelling. To me, it should have been over at that point back in October. So as we move forward, I think we need to be careful as a community because there's a bigger picture at play here. They're going to try to change it. So you gave stipulations that it wouldn't be a separate address. It had to tie to the house. Everything that's been touched here today, I won't go down in those weeds. But at the end of the day, R2 protected these properties as single-use family dwellings, and here we are. So it's kind of like the old days, not to be mean, but Indians, give us your guns. The government's going to take care of you. That's kind of what we have going on. This is going to be a problem down the road. So we're in a conundrum here, obviously, from October to today, but we need to do the right thing as a community because we're going to have unintended results if we approve this. Big picture. Thanks for your time.
Thank you.
Trying to conclude my piece, if you don't mind. I think we're at a point. I appreciate those who've done the homework the city should have done. The precedence is very scary if I look at it for the financial future. I think it's very concerning for established neighborhoods in Elkhart. We're building apartments on a regular basis. We've had 3 new assisted living buildings put up in Elkhart in the last 5 years. We have what is needed. There are additions that are being put on properties, but the investment can also stop if you feel as though your investment is not stable. Therefore, there's a reason why people go to the northeast quadrant of our city and invest money. It's the most stable area of the city of Elkhart, and this does the opposite for it. In my opinion, and having viewed the original notes, I'm the representative for the area. The first notification I had was from neighbors when the trailer was on the wheels and sitting in the front yard. I called Mike Huber, I called Eric Trotter, trying to get clarification of how this could happen. That was my notification early on. The first indication I had that this was a possibility. Neighbors immediately started to call the city, call representatives. We were all involved, and yet the project continued. I do believe after viewing these documents, after hearing the neighbors, who did such a good job investigating the law in this matter, that misrepresentations of the project did occur. The language was purposeful. We talk about the 3 measures that are most important to a BZA. So all the emotional response had nothing to do with anything. It was just noted to muzzle off some other statements, but was allowed in the original presentation. The lack of transparency and validation brought extra city officials in to this meeting, so we knew there was a problem. When city officials have to step in, staff of the administration, and try to come up with a game plan on the second meeting that the public was now involved with. That's a problem.
These are actually the people that are always in our meetings. Maggie's usually.
Yeah, this is as much as this is more than the attendance of a city council meeting.
But these are people that have come to speak also, so.
So because of the transparency, because of the lack of validation on city officials, we should know these answers before this meeting. Opens the city to legal recourse. Petition has already started. This is a harmful precedent. Therefore, I think we are requesting a unanimous denial of this process with a cease and desist, and then allow the petitioner to reapply under the now known facts, measures, and application. Protect the process of the BZA. That's critical here. The process has to be the process. But it didn't go well, as you now know, and you probably have known before, and Maggie even alluded to, notifications didn't get out to where they needed to go. That's a violation of due process. So I believe in everyone's best interest, even the petitioner. If there was a unanimous denial, there's enough change that she qualifies to reapply for a variance under the now known facts, and let the BZA do its job at that point. Thank you.
Thank you.
So to be clear again for everybody, the only thing that we are hearing today for variance use is for square footage and then the number of buildings that can be accessory dwellings, and then if it can be habitable or not. Okay. Is there anyone else that would like to speak in opposition? Anybody online?
I just want to point out at the very start, I believe I clarified for everyone that these were all being heard as new petitions. So I'm just pointing that out again in order to address Councilman Henke's comments that there should be a new petition. Well, that's what today is. And the facts are known. And I think the reports were supplemented by staff, by the petitioner, and by a number of people who have come up here and spoken. So that's what today is. It's a new petition. Okay.
I just want to add on to something I discovered as I was talking to her.
Can you speak your name?
Yeah, I want to,
Thank you.
excuse me,
Your name and then.
Adrian Byers.
Thank you.
You know, as I was moving around the neighborhood, obviously there are a few neighbors that are looking to move. Not because of, what's occurring, it's their previous plan to move. And, without this addition, and of course, Nicole and her family had no clue of the impact. But, we're here to make sure that, any homeowners property, that's their number one investment, and to maintain equity in that is important. And even though the property value of the 1746 East Beardsley increases, that doesn't necessarily mean the property around it will. So essentially, as a neighbor across the street who wants to move to St. Louis and she puts her house on the market, she may end up getting less than that. There are 3 neighbors that are looking to move, and there's 3 houses on Beardsley for sale. So that's 6 houses. So this is kind of the heads up for you guys in terms of we're just sounding the alarm. I mean, it's in our front yard today, but it'll be in your backyard tomorrow. So it really is something that needs to be taken into consideration. And if it's done right, here again, ADUs, I have nothing against them if they're done right. So I'm just making sure that, we understand that there's no sympathy applied to this. There's the law, the Indiana law, in terms of how the variance should be utilized. So with that being said, just have to do your homework and make sure that, we don't get ahead of ourselves because we are now. This is pretty much 90% complete, and the permits, the approvals, it's not completed. So it's almost self-inflicted knowing that there was an issue. Neighbors, citizens have complained, and there was no cease and desist that was talked about before. So this is a kind of a self-inflicted situation, and it really isn't between the citizens and the board and the petitioner. This is between the petitioner and the city. That's basically because, obviously you failed her and maybe you guys were misled in getting to this point. So this is just, I'm sounding the beacon, the warning here to make sure that the next time this comes up, that there'll be a little bit more attention paid to the details, not only above the ground, but even below the ground. You know, we've got an aging sewer system on the north side of Elkhart. We have more industrial growth on the northeast side from the commercial buildings. That sewage system can only handle so much. So if we keep tapping into old cast pipes, and hopefully when someone comes across a pipe from 1932, they know how to connect to it. Maybe, maybe not. You know, these are going to cause infrastructure problems that are going to be a cost to the taxpayers. So essentially, putting that in the neighborhood, unbeknownst to her, she said, I just took 10 grand off your property value, 10 grand off your property value, 10 grand off yours, and it could be more than that. But that's basically the reality of that when it comes to someone coming into the area and saying, I want to buy a house and see that structure there. Thank you.
Michelle Corich, I just want to be specific. We object to the variance to allow this larger unit trailer to be put. So the specific thing you're hearing today is that it's too big, and that is on your docket for today. So we, the citizens, are saying, no, thank you. We would like you to vote no.
Is there anyone else that would like to speak in person or online? Okay. At this time, we will close the public hearing and hear the staff report.
The petitioner is requesting a use variance to allow for the construction of a detached accessory dwelling unit that is 748 square feet in area. Section 4.2 permitted uses in the R2 one-family dwelling district does not permit accessory dwelling units plus the number of accessory structures in square footage. The request comes to us as the petitioner is looking to build a detached accessory dwelling unit, in the rear of their property for a family member. The parcel is currently used by the petitioner's primary residence as a single-family home. The need for the use variance comes from the fact that the R2 zoning district does not permit accessory dwelling units as a permitted use. The petitioner reached out to staff during the necessary due diligence in order to establish the use. The petitioner was made aware at that time that board action would be required. The number of accessory structures on the property is currently 3. With the added ADU structures, this raises the total number of structures to 4. Should the BZA approve the request, one of the sheds should be removed. From the street, the detached dwelling will have the appearance of a house in the backyard. Only one entrance will be permitted on the front facade, while a second entrance can be on the side of the rear of the building. The structure will be secondary and accessory to the main dwelling, as the ADU will be fully functional as an independent living space from the primary dwelling. All utility connections will connect into the primary dwelling. This ADU will meet accessory structure setbacks. The ADU will be on the same lot as the primary dwelling and will be not split off in the future. The primary structure or ADU must be occupied by the primary owner of record and will be recorded with the Elkhart County Recorder with a deed restriction. This request will allow the property to add housing variety and continue to chip away at the shortage of housing in our community as outlined in the Zimmerman-Volk Housing Study. The city needs housing at every level, and this request helps the city in promoting incremental increases in housing options within existing neighborhoods throughout the city. The city of Elkhart is in the process of updating its zoning ordinance, including accessory dwelling unit regulations. It is anticipated the UDO accessory dwelling units are listed as special exceptions with conditions. The requested conditions are consistent with proposed regulations found in the anticipated UDO. Staff anticipates seeking more requests similar to this one following the anticipated U being implemented. Staff recommends approval of the use variance based on the following findings of fact. Number one, the approval will not be injurious to the public health, safety, morals, or general welfare of the community because the detached building will be built per all applicable building codes. Number two, the use and value of the area adjacent to the property will not be affected in a substantially adverse manner because the surrounding uses are residential and are residential structures. Number three, granting the variance would be consistent with the intent and purpose of the ordinance because a small measure of relief when uniquely warranted. Number four, special conditions and circumstances do exist which are peculiar to the land involved, which are not applicable to other lands or structures in the district because without board action, the adding of the accessory dwelling unit on this parcel would not be permitted. Number five, the strict applications of the terms of this ordinance will not result in practical difficulties in the use of the property because the owner would not otherwise be able to place the structure. Number six, the special conditions and circumstances do not result from any action or inaction by the applicant because no construction has yet begun. And number seven, the property does not lie within a designated flood hazard area. Conditions, should the board choose to approve the requested developmental variance, staff recommends that the following conditions be placed on the approval. Number one, only one entrance is permitted on the front facade while a secondary entrance can be on the side or rear of the building. Number two, this shall be secondary and accessory to this main dwelling. Number three, shall be fully functional as an independent living space. Number four, shall be on the same lot as the primary dwelling and not split off in the future. Number five, must meet accessory structure setbacks. Number six, primary structure or ADU must be occupied by the property owner. A deed restriction shall be recorded with the Elkhart County Recorder. Number seven, utility connections must connect with a primary structure or primary dwelling. And number eight, the removal of one shed from the property to allow for three total. And staff would add an additional requirement that the homeowners provide a survey to confirm the correct placement of the ADU on the property. And additionally, additional comments, the Indiana Association of Realtors is strongly in support of House Bill 1001, specifically streamlining approval of ADUs without public hearing. Number two, the BZA is considering the use, not whether or not the ADU is a manufactured home. And we have provided a deed restriction which will require the property to be maintained as a primary structure, the primary owner of record in either the primary structure or the ADU, and the structure may not be subdivided in the future. There were 39 letters mailed. And give me just 1 second. There were 11 responses received and all 11 not in favor with the following comments. And actually there were, I apologize, 1, 2, 3 additional received today.
You got one more. You want to?
Thank you.
So does that make it 12? And
12 and plus an additional 3.
I did include all of the ones we received today in that number.
Okay,
So
thank
12.
you. I talked with Nicole when receiving the first notice from the zoning department. She wanted to build a little house for her mom because she lives in Goshen. That's too far to go and check on her. I agreed with the impression that was going to be a small home built based on that conversation. When construction began, I saw there was a lot of soil piled up next to the fence. I went to talk to the person. He didn't know why they had put pylons in because the owner said it was temporary. The mobile home was delivered and left in the side yard the week of January 19th. It was placed in the backyard on the 21st. According to the diagrams presented, it was option 2 was chosen, but instead 16 feet and indicated it was 5 feet from the fence. The floor plan submitted shows a two-bedroom, has a window and a bathroom on the other end of the home. 13.4 foot wide side has no window. You will also notice the primary building or primary bedroom and living room have a window and an entry door. My photos shows the end of the home has a window facing the street and two windows and a door facing the fence. This front of the home is facing west approximately 5 feet. I was told by Amy Latimer, the code states the front door has to face the street. It does not. The proposal shows it 15 or 16 feet away from the fence. It is not. In paragraph 6 of the appeal, it stated the occupant already requires assistance at times in keeping up with the housework and yard work. While this may be true, she still works 40 hours a week and informed me when I met her, she has 3 or 4 years to retire. If the structure was moved to a mobile home park in Elkhart, it would be close enough for Nicole to help her mother until her mother needs assisted living. Nicole stated in her appeal on number 7, wouldn't bring hardship to the neighbors. It will in fact lower property values, make it harder to sell the home, and cause the neighborhood to appear less desirable to future home buyers. I'll summarize this. The neighbor did not receive notice and she lives down the street. I hope you're doing well this week. I'm reaching out today in regards to the letter I received ahead of the public hearing to address case 25 UV 10. I will not be able to attend in person. I hope this letter might voice my stance. I'm the homeowner at 1728 East Beardsley. The accessory dwelling is being discussed 2 doors down from my home. While I did not receive notice in the initial hearing last fall, I do appreciate the effort to include this in a mulligan. I find myself deeply hesitant to write an opinion of my neighbor's land use, although I am struggling with my view as of late. As an owner of a larger lot on East Beardsley, I find myself curious about the future landscape of our block if this item is allowed. In the event I approached the city as well as to create a second dwelling in my backyard, I could very easily create a mini trailer park to the delight of every homeowner. We share backyard views on Grant, Independence, and Beardsley. I do not foresee my neighbors being too terribly enthused by the idea. I'm not in favor of the variance request as it stands and hope to be reconsidered or perhaps revised to allow manufactured homes. Thank you for your time. We recently learned of the variance request on February 16th. We reviewed the minutes of October 9. We have several questions. Mr. Trotter said 23 letters were mailed. We never received a letter. Can you provide the names and addresses of those who were sent a letter? It surprises me that no one in person to hear about the variance request and only 2 replies to the letter were received. The U.S. Mail and the Elkhart Truth are not reliable methods to contact affected people. Petitioner states she'd like to build a new home. Currently, there's a mobile home sitting in the back corner of their lot. How is this build a new home? This is not a mother-in-law suite. It's a mobile home. Is this area zoned for mobile home? Did the petitioner show you pictures of the ADU as it was a mobile home? Staff recommendation number 2 states the value of adjacent property will not be affected in a substantially adverse manner because the surrounding uses are residential and residential structures. The surrounding structures are houses, not mobile homes. This ADU sticks out and it's extremely noticeable as you're driving by along East Beardsley. It's a very busy street. Recommendation number 4 states the special conditions and circumstances do exist which are peculiar to the land involved and which are not applicable to other lands or structures in the same district. Because without board action, adding the ADU on this parcel would not be permitted. There are at least 3 other double lots between this one and Austell Road on East Beardsley. This is setting a precedent for mobile homes to be placed on these lots. In the staff analysis, all connections will connect to the primary dwelling. This includes water, sewer, and electric. Staff analysis, the ADU, the mobile home will be on the same lot as the primary dwelling and will not be split. The primary structure or ADU must be occupied by the property owner of record and will be recorded with Elkhart County Recorder with deed restrictions. So when mom no longer occupies the ADU, what happens to it? When the current owner primary moves, what happens to the ADU? Does it become a rental property? Is this zoned for rental property? Are the utilities separated from the primary structure? Has the fourth shed been removed since the ADU is currently on land? Mr. and Mrs. Moore strongly object from the variance of adding the ADU on the second lot for the following reasons. Petitioner has moved a mobile home onto her second lot. Building a small house that would blend with the neighborhood is different than a mobile home. It sets a precedence that encourages other neighbors to ask for the same variance and put a mobile home in their yard. In this area is zoned R2 single-family dwelling. Adding a habitable ADU to this area emboldens others to add a unit to their land and convert an existing ADU such as a garage, shed, or habitable structure. We disagree with the statement in the staff's recommendation about property values not being affected in a substantially adverse manner. In the past several years, houses have been renovated and improved. Putting mobile homes on the street will decrease our property values and desirability to live there. Would you want your neighbor to put a mobile home on the house next to you? Mr. and Mrs. Moore strongly urge you to rescind the decision or deny approving the dwelling unit at 1746 East Beardsley, allowing an accessory dwelling unit to be put on their lot. We strongly urge you to rescind or deny the use of the ADU for permanent or temporary habitation. First, let me be clear, I'm opposed to this petition to put a mobile home at 1746 East Beardsley. It will cause harm to the value of my property, which I recently purchased in '25. I would not have purchased this house if there was a mobile home placed on any property nearby. Additionally, the current placement of the monstrosity is so close to the neighbor's fence, and the front door is facing the fence and not the street. The mock-up provided by the petitioner does not indicate where the front door is and seems another example of trying to pull a quick one. Most would assume the front door would face the street, but that isn't how it's been placed. I viewed the October 9 zoning board meeting, and it seems the petitioner lied to the board concerning the accessory building. It was said to be a constructed home, building cute house for mom. It's not the same as pulling in a mobile home. The zoning board was misled at the meeting. I'm also concerned that I did not receive a letter in September concerning the petition. Speaking with my neighbors, they did not receive one either. Lastly, I've included photos of the property and ask you, would you want this across from your home? Both my wife and myself are strongly opposed to the ADU. A short while ago, my wife and myself saw a mobile home parked on the side of the lot at that address, and we both went ballistic. A day later, it was gone. We forgot about it now. Do they want to make it permanent? No. I'm ready to share my concern regarding the recently installed single-wide mobile home styled ADU in our neighborhood. First, I want to acknowledge the clear and compassionate intent behind this decision by our neighbor. Providing care and proximity for an aging parent is admirable and reflects strong family values. My concern is not with the motive, but with the long-term implications for our neighborhood. We have lived in an established area of homes built primarily in the 1930s through the 1960s. The architectural consistency, lot usage, and overall character of our neighborhood are part of what protect its identity and long-term property values. Introducing detached single-wide ADUs represent a significant departure from that pattern. My concerns are threefold. Precedent. Allowing the structure sets a precedent for future installations. Once established, it becomes increasingly difficult to deny similar requests regardless of circumstances. Neighborhood character. A mobile home style ADU materially changes the visual and structural consistency of our neighborhood. Over time, incremental changes can significantly alter the feel and desirability of the neighborhood. Property values. While a single instance may not create immediate impact, broader adoption could influence buyer perception and long-term house values. Established neighborhoods derive value in part from stability and predictability. I respectfully urge the board to carefully evaluate both its installation and any future requests for similar structures if ADUs are to be considered. I would strongly recommend clear architectural and structural standards that align with the existing character of the neighborhood rather than allowing mobile or manufactured home style units. This recommendation includes this latest structure if it continues to be allowed. My intent is to not criticize the neighbor's personal decision, but to advocate for the long-term sustainability and integrity of our community. I'm writing to formally express my opposition to the proposed placement of the mobile home on the property that already contains a single-family dwelling within our neighborhood. Based on the Board of Zoning Appeals, injury to neighborhood standard of variance or special exceptions should not negatively alter the area's established character, create hazards, or cause unreasonable injurious effects on neighboring properties, including property values and enjoyment. I believe this proposal conflicts with those standards for several important reasons. Alteration of essential character. Our neighborhood is composed of traditional single-family homes on individual lots. Introducing a second dwelling in the form of a mobile home on a lot designed and zoned for single-family residential use would substantially alter the established character of the area. The placement of an additional structure of a different housing type changes the residential density and visual consistency that homeowners relied upon when purchasing their properties. Physical and aesthetic impact. The addition of a mobile home is not to a lot already containing a primary residence, increases structural density, and may create visual overcrowding. This type of modification can dominate surrounding properties and disrupt the cohesive appearance of the neighborhood. Lot configuration and spacing and scale are important factors in maintaining neighborhood integrity. Impact on property values. Homeowners in this neighborhood have made significant financial investments based on existing zoning and development patterns. The addition of a mobile home on a lot with an existing residence may create uncertainty for future buyers and could negatively influence comparable sales values. Perception plays a significant role in residential real estate markets, and deviations from established neighborhood standards can result in decreased demand and result in reduced property values. Precedent concerns. Approving this request may set precedent for similar future requests, gradually transforming the neighborhood in a way that was not originally intended under current zoning classifications. For these reasons, I respectfully request the board deny the variance in order to preserve the integrity, stability, and property values. ADUs are prohibited in the R1 and R2 district, meant for one-family dwellings, doesn't suit the characteristics of the neighborhood, sets a bad precedent for future home development, may diminish surrounding property values, could discourage proper house development in the area. No pathway leading to ADU, driveway to EDU, or privacy fence surrounding the backyard. Is there an affordable housing crisis? If there's an affordable housing crisis in Elkhart, this is not a prudent way of resolving that issue. I think that's everything.
Questions for staff?
There's a lot of information that has been provided to the board. And I'm going to ask that if we can move this, Eric. I'm not comfortable with making a decision at this time based on the fact that we have just gotten all the information we needed, and I like to scrutinize that to the board to see if this could be moved at another time, since this is our first time going through.
What are you asking?
Can it be moved to another date?
Oh, to table?
Yep. I don't want to approve it or deny it at this time.
As a board member, that is your prerogative.
Can we ask some questions that will maybe help us decide either way at this time?
Could I?
Sure.
I just want to, I think there is a misconception based on a number of comments and some of the letters. The BZA is serves a quasi judicial role. They do not set precedent. So if you deny this one, that doesn't mean you have to deny every ADU. If you approve this one, you don't have to approve every ADU. You hear things on a case-by-case situation, and you are supposed to weigh the evidence, the merits, all of that. On individual cases, you are not setting precedent. there's certainly, you would expect to generally follow, but don't feel like however you make your decision in this case is absolutely shutting the door or opening the door on future cases. I just wanted to make that clear as your attorney.
Thank you.
Now, I think Eric has, I think they want to ask you some
Questions.
questions.
I have questions about parking and driveway and how that's going to work with the structure if approved.
In the interim, they would use the driveway that is there.
Okay.
And if they chose to submit for a second curb cut, that would be theirs and would be looked at by the Public Works Department and ours at the same time.
Okay, so currently they are not allowed to drive over the grass and the sidewalk and everything else.
Correct.
Do we need to add that in as a condition, or will that be enforced by the city, or? how
If you
does-
wanted to place that as a condition, you could. I mean,
Okay.
it would be enforced by the city, but if you wanted to place it as a condition, you could.
Um, and this might be a question for Mike possibly on, as, I'll wait for you to come up. Hi. Can you speak to the structure of the building, if it has been inspected? Is it within code, et cetera?
I believe we'll probably have to do some verification on the actual inspections that have been taking place by the building department. Again, zoning clearance is one part of the building permit process. They would have come in, they would have applied for and provided all the relevant information necessary to receive their building permits. And then that would have triggered the relevant and necessary building inspections all along the way. But we can definitely verify and provide the board with the additional information that we can get from the building department related to those pieces.
Okay. Because I think that will help with the 16-foot that was proposed and that we,
And to address that, again, I believe that the variances, the only development variances that were given today were related to the number and size and square footages. There weren't any setback variances, developmental variances that were requested, or so if the structure was not placed, if it was placed encroaching on a setback, that is something that from an enforcement standpoint could be remedied, and potentially the structure may have to be moved.
okay. That was, I think, why Eric had proposed the condition of having a survey done. Is that for that purpose, Eric?
That's correct.
Okay. So. Let me, how does this work? I've closed the public meeting at this time. Maybe it will, I'm just going to reiterate one more time for everybody. So maybe this will help you understand what we are actually up here today to do. It is to approve the square footage, which will actually change these numbers here a little bit because they are removing a shed. It is also to allow an additional building, accessory dwelling to be placed in the yard. And then the habitation. So those are the only things that we are dealing with today. It's not the square footage, the encroachment, that type of stuff. The city will do their due diligence in making sure that that is up to code. So hopefully that helps with your question. I can't speak to that because that is not, these are the only three things that we have the ability to grant a variance use on today. So it's just those three things, just to be very clear. Okay. Okay. Are there any more questions for staff?
Nope.
Is there anything that you would like to add?
Nope.
Okay. Okay. All right, at this time, I'd like to call for a motion. With the added conditions of Eric. Eric, do you mind restating those for us really quick? The added on conditions?
We had the 8 from the staff report, and we added a 9th, that the homeowner shall provide a survey to confirm the correct placement.
Okay. It was just the survey. I would like to add a condition, if possible, regarding parking and a driveway. I think those need to be followed with city code. I'm not sure exactly what that is, but driving over the sidewalk is hazardous. So we just have to make sure that that is handled correctly with the city. So that would be my added condition, to make sure parking is within zoning ordinances. Okay. Anything else?
No.
Okay. This time I'd like to call for a motion. I'd like to, sorry, can I add one more thing onto the condition? We have already stated that a building would be removed, the shed. And I know that that's in the works, but I think we put a cap on it at like 60 days. So it's expedited and it's within. So I will, hold on, let me find it on here. So on the condition number 8, the removal of one shed on the property to allow for 3 total structures within 60 days. Yes, Meg, did I do something wrong?
No.
Okay.
I just wanted to share additional information because I know there'd been some concern. If the board does not, because you only have a quorum with no additional members here, if you don't reach a unanimous decision, it stays tabled.
Okay.
It's not affirmed or denied or approved or denied. It just stays tabled for the next regular meeting.
Say that again?
We all 3 have to agree unanimously if it's approved or not. If one,
Approved or denied.
or denied, yes, approved or denied. If we don't all agree, then it will be tabled for the next meeting when we have 4 people. Or a quorum
Whatever.
again.
Yeah.
Yeah, that's.
I don't know what that means.
I'm
Why would-
advising the board on the voting.
Yeah, that's something we normally do anyway. As long as we have a quorum, which we do today, we just have to be in unanimous voting. Understood?
So the residents that came today will have to come again.
If we don't decide on the same vote.
Who needs, I mean, we'll ask you to vote your conscience.
Mhm.
One question. Assuming you have to table this, Does that mean the project?
Let's take our vote and then we can address anything at that point.
Thank you.
Okay.
So you know.
Okay, yes, at this time we'll take a motion.
Okay. Deep breath. Based on the information presented to the board, I move to deny variance 25 UV 10 because of the following conditions or conditions have not been met.
Second.
Wait, I'm not done. I have to list why.
Conditions.
The approval will, use variance requires that the approval will not be injurious to the public health, safety, morals, and general welfare of the community. The use and area, value of the area adjacent to the property will not be affected by a substantially adverse manner. In both cases, the petition before us today does not meet those standards. Therefore, I am moving that the variance be denied.
Can you read into record which variance it is?
Okay, so the variance, oh, sorry, 25 UV 10.
Do we have a second?
Second.
Lindley,
Yes to deny.
Newbill,
Yes.
Lightman,
I'm going to say no to deny. So we are not in a unanimous vote, so this will be heard at the next meeting.
What a cop-out. You copped out.
Does the project stop then? Or say, do they just continue?
Eric, could you speak on that? Or Maggie?
Yes, we are going to be contacting the building department about ceasing, moving forward. Yes.
Yes.
When is your next meeting?
Eric, are we having our normal Thursday meeting? Here, I'll tell you right now, 1 second.
March
March 12.
Okay. At this time, I would like to call a motion to adjourn.
So moved?
Second.
Roll call.
Lindley,
Yes.
Newbill,
Yes.
Lightman.
Yes. Okay. Thank you to everyone who came out today.